Hello, my name is Andrew Burridge.
And my name is Jess Hambly.
And we are summarising our paper in which we discuss how absence is missing in legal geography and studies of the law, drawing on multi-sited ethnography of European asylum appeal hearings.
Our research demonstrates the importance and productivity of thinking both about law's omnipresence and the absences that shape the way law is experienced and practiced.
We discuss both physical absence of evidence and participants in asylum court appeals, as well as mental absences. Our intention is to offer new ways for legal studies to account for absence.
We identify 3 reasons to pay attention to absences. First, conceptually, we argue that absence is intrinsic to presence.
Second, studying absence helps us to understand court hearings beyond surface appearances. If we perceive the courtroom as a theatre, that reproduces social hierarchies and reinforces marginalities. It is necessary to consider not only what can be seen, but also what is missing and how these absences further exacerbate classed, racialised and gendered positions.
Third, the view of legal spatiality or omnipresence, that is, that law is everywhere, risks obscuring the fact that legal rights are often experienced as inaccessible by marginalised groups such as asylum seekers.
Thus, rather than viewing presence and absence as antonyms, they may exist simultaneously. In our paper, we argue that presence and absence can take multiple forms, and thus requires a plural approach.
Our paper draws on ethnographic observations of over 850 in-person asylum appeal hearings in Austria, Belgium, France, Germany, and the UK between 2013 and 2019. The importance of asylum appeal hearings overall cannot be overstated. Over a third of initial decisions in the EU28 were overturned between 2017 and 2019.
We discuss how hearings were haunted by absences. Asylum appeal hearings are highly dependent on documentary evidence, which were often reported as missing, incomplete, or misunderstood, even if managed electronically.
We often observe the physical absence of asylum applicants who missed the opportunity to provide clarification on points of confusion or contestation, exposing them to negative moral judgments by both government representatives and judges.
We note the frequent absence of appellants' legal representatives, owing to various factors such as legal deserts or lack of legal aid.
We observed the absence of government representatives, shifting the burden of interrogating appellants from the government to judges.
We discuss courtroom technologies such as video links. Although the asylum appellant being virtually present, we note the changes in atmosphere, speech and behaviour of parties.
We mention other absentees in court hearings, such as court writers, leading to interruptions in the flow and dynamics of conversations.
We also observe participants in the hearing being simultaneously physically present and mentally absent from the events, often to the detriment of engagement, deliberation and legal quality.
Partial presences also occurred in judges, noting the impact of time pressures, workload, fatigue, detachment to avoid secondary trauma, and disinterest and apathy among judicial staff.
Appellants may be simultaneously present and absent or unable to concentrate due to communication difficulties, physical ill health, discomfort, destitution, mental ill health, nervousness, as well as the presence of children in the courtroom distracting parents.
The asylum appeal system is at the heart of wider absences and exclusions. Rather than portraying law as benign and consultative, the formalism inherent to hearings disguises important gaps, power imbalances, and instances of non-coherence in courts.
Our paper sheds light on the systematic under-resourcing of this legal area. Resourcing is ultimately political, reflecting the value that European societies place on protecting refugees and meeting their international obligations.
Attending to legal absences shows that law is everywhere and nowhere, omnipresent and fleeting. Adopting a view that's sensitive to the simultaneous absences and presences of the law allows us to critically attend to the practicalities of access to justice, while distancing itself from the fantasies of universalistic human rights laws.